Good afternoon, everyone. Thanks for joining us today for PilieroMazza's webinar, Cybersecurity for Government Contractors, Success Through Compliance Readiness. My name is Kevin Barnett. I'm counsel in the Government Contracts Group, where I chair our claims and appeals teams. I spend a lot of my time counseling on both claims, REAs, and performance disputes, which has, in a lot of times involved cybersecurity counseling and advising companies on, responses to cyber breaches. I've also advised companies on attorney-client privilege matters related to their incident response. With me today is Daniel Figuenick, who is an associate with our cybersecurity and data privacy team. Daniel helps advise government contractors of all sizes on their cybersecurity obligations. He also helps out with a little bit of everything.
Yeah,
today we're here to talk about the importance of cybersecurity. I think it is quite the buzzword. We hear about it all the time. It's the future. It's really not even the future. It's today. Roughly $600 billion is lost annually, and that number is probably comically low compared to what the actual loss is for bad actors exploiting inadequate cybersecurity. The Biden administration has made it a national priority. There have been several executive orders issued under President Biden with a focus on national security, and that has led to a number of rules and new regulations and forthcoming rules that we're going to talk about today. In particular, DoD has been leading the charge over the last few years implementing those cybersecurity regulations. However, the rest of the supply chain and the rest of the government agencies are quickly following suit. So, Daniel, can you tell us what we're going to be covering today?
Yeah, definitely. Yeah, so here are some of the topics we're going to be covering today to kind of give you a lay of the land for cybersecurity in federal government contracts. So first, we're going to take a look at some of the Federal Acquisition Regulations, general cybersecurity requirements that some of you may already be familiar with. Next, we're going to dive into some of the notable agency-specific requirements, including a few that were recently rolled out and that we think you should be on the lookout for in your contracts. Following that, we will see how the government-wide focus on supply chain risks is coming into action through various different contract clauses and interim final rules. Then, in the end, we'll be briefly explaining why these cybersecurity regulations are significant, including some of the potential liabilities and risks for those that do not comply, as well as some general next steps that we think contractors should be taking now and in the near future. To kick it off, one of the fundamental ways the government tries to safeguard and protect its information is through Federal Acquisition Regulation, or FAR, Clause 52.204-21, the basic safeguarding of covered contractor information systems. This clause requires contractors to implement 15 basic controls to protect any covered contractor information system. What is a covered contractor information system? It's any system owned or operated by a contractor that processes, stores, or transmits federal contract information, or FCI. So FCI is one of those buzzwords and one of the two categories of information we're going to be focusing on today predominantly through the rest of this webinar. So FCI is defined as information not intended for public release that is provided by or generated for the government under a contract to develop or deliver a product or service to the government. So significantly, this definition does not include information provided by the government to the public, such as information on public websites or simple transactional information, such as information necessary to process payments. And so this clause and its requirements must be flowed down to any subcontractor with or access to FCI, federal contractor information. So here is a list of some of the different controls from that FAR clause. I'm not going to go through all of them, but most of them are fairly straightforward and simple. But for example, the clause requires contractors to provide access to the relevant systems only to authorized users and ensure their contractors are escorting their visitors as well as monitoring visitor activity in or on or around their covered information systems. And in addition, any system flaws in these systems should be identified, reported, and corrected in a timely manner. And contractors should also stay up on top of any periodic scans or updates to antivirus software to protect them against malicious code in the information systems.
The absolute minimum a contractor or really any business should be providing for cybersecurity. These are very much the floor of what the federal government expects. It's also the floor of what most businesses would expect, and most insurance companies would expect.
Awesome. So here, so that's why we've been, just as Kevin mentioned, we've been discussing some of the basic controls when it comes to contractors having access to federal contract information. So the other large bucket of information that we're going to be talking about today that requires safeguarding and protection is controlled unclassified information, or CUI. So we want to stress the significance of these two terms and put the definitions up here on the slide for you. You'll notice the definition for CUI is pretty broad and vague, and it comes from the general CUI regulations that provide a sort of basic framework for all agencies to safeguard CUI, but agencies tend to implement their own, and often do implement their own rules regarding the safeguarding, disseminating, and the marking of CUI. So, for example, in DoD contracts, contractors should look out for specific DFARS clause 252.204-7012, which Kevin will be discussing in greater detail shortly. And as I just mentioned, agencies do tend to implement their own rules regarding the CUI. Many agencies like NASA and HUD have their own requirements regarding CUI in various contract clauses in their FAR supplements. So I think from a bird's eye view, it's helpful to start off with the two different definitions of FCI and CUI, but somewhat abstract. So we're going to kind of walk through some examples of both FCI and CUI. So first, right here, we got some examples of federal contract information. These can include construction plans for military bases, non-public performance work statements or drawings and specifications, as well as CPARs, which many of you are familiar with as government contractors. And in addition, any correspondence between you and the government that's not intended for public release is likely going to be deemed FCI as well.
What I find so interesting about these examples, Daniel, is that they're really spanning the entire gambit of government contract industries, and hit on some industries that aren't really at the forefront of what you would think of as cybersecurity targets. Construction plans, drawings and specifications. Those, the manufacturing companies or the construction companies may not be thinking that they are, they're not IT companies, they're not data companies, they don't have all this information flowing through them, they're not a cloud company, so that cybersecurity is important. And then really, probably the opposite is true, is cyber is extremely important for those companies. And, because of the presence of FCI, if not CUI, the FAR clauses we're going to talk about, that you have already talked about and we're going to talk about later, are all triggered.
Great. Thanks for that, Kevin. Yeah. So going off of that point, we just talked about some examples for the very broad definition of FCI. But here are some examples of controlled unclassified information, or as we're going to refer to as CUI. I think it's important to remember that the information in these categories, and this is not an exhaustive list, we just pulled some of the categories from the CUI registry. The information in these categories has been deemed important and sensitive by another law, regulation, or order, and must be safeguarded, protected, and marked in accordance with the relevant guidelines. It's consistent with CUI definition. So a full list of CUI in the categories is located at the CUI registry on the National Archives website. Shouldn't be too difficult to find. And it is important to know, we think, that while the agencies are generally the ones tasked with identifying and properly marking CUI, we think it'd be a good business practice to independently determine whether your company is handling any CUI and, as a result, are subject to these various requirements regarding disseminating and handling and safeguarding.
Yeah, CUI is historically very difficult. The definition is very, very confusing, and what exactly is or is not CUI is a very thorny issue. In theory, it should be any document marked with one of the National Archives dissemination controls. However, the DoD IG just issued an audit report this week talking about how, I'm going to get these numbers wrong, but DoD, 9 out of the 10 components that they looked at fail to properly mark CUI on a regular basis, and that well over half of documents that should have been marked CUI were not marked CUI. And by comparison, they also looked for those same components at what contractors were doing, and contractors fared much better. They were properly marking CUI in 97% of the cases. So while we should be able to tell you that you can rely on the agency to mark what is and is not CUI, they do not do a good job of it. And it really falls on you as the contractor to ensure that you know what type of information you have so that you are providing the proper protections. And it is very appropriate for any areas where you're not sure if what you have is CUI or not CUI to raise that question with the contracting officer or the Corps or the program manager and say, hey, these documents, they're not marked, but they seem like they fall under these dissemination controls. Is that correct? Can you help me with that? What's going on with those? Because we just talked about the basic safeguarding, and I said that's what most companies have that in place without even being required. They may have some adjustments there. But DoD imposes a heightened requirement if your contract, if the contractor's IT system contains CUI, or because we need to be difficult and have a different acronym, it's actually technically if the IT system has covered defense information. But for the most part, covered defense information and CUI are synonymous. So DFARS 252, 204, 7012 is the safeguarding of covered defense information in cyber incident reporting. And DoD has been including this in most of its contracts because there is, like I said, the definition of CUI is very broad. And what this requires is essentially, adequate security. What does adequate security mean? That means your system needs to correspond with the latest revision of NIST Special Publication 800-171. It's currently on revision 2, although revision 3 is out for comment. And that is 110 additional controls beyond the basic controls that we listed. Things like dual factor authentication, heightened scannings, encrypted email are all requirements. It also, for any time you have CUI that's being stored or passing through the cloud, that cloud provider needs to be FedRAMP Medium certified, which is a whole separate process. And it indicates that they have a certain level of security associated with their cloud computing. In addition, the -7012 clause also requires reporting cyber incidents to DoD, to the DIBnet website, within 72 hours. 72 hours is not a lot of time. We joke sometimes with the people in the bid protest group that, they think their deadlines are short. You should talk about anybody having to do incident reporting where, most of the time you can't even figure out what has happened in 72 hours, never mind start reporting it to DoD. Also significant here is you need to flow down these controls to subcontractors who also may be handling CUI as part of the subcontract. This is really what I talked about about NIST 800-171. There are 14 security families related to those 110 controls. And actually, if you look at the assessment guide, there are something like 362, I think that's the number, objectives associated with these controls that you have to meet each of those objectives. The thing about it is NIST 800-171 is not easy to comply with. Companies, when this first got rolled out in 2017, almost no company was able to comply with the entire menu of requirements. And so they started implementing POAMs, which were proactive, action plans for when they were going to get into compliance. More recently, DoD has gone to a series of self-assessments or DoD assessments to enforce the NIST 800-171 requirements. They have this tiered system of enforcement. The DFARS 252-204-7019 clause requires contractors to engage in a self-assessment of their NIST 800-171 compliance and enter that score into the CPRS system, showing how many of those controls that it meets and what the plan is for meeting any controls that it does not. There's also the -7020 clause. And what the -7020 clause is, it actually allows DoD to come in, and contractors have to provide access to their systems, their facilities, and their personnel in order for the government to conduct a medium or high assessment. And the contractor will have an opportunity to offer a rebuttal if they disagree with the results of that high assessment. But that's a daunting idea that DoD can just come in and start auditing my system. As DoD has started to roll out these audits, they've given us they've released some of the results and told us at a high level, at an aggregate level. And it's kind of astonishing how poorly companies are doing, and especially how poorly companies are doing in respect or as compared to their self-assessment. DoD looked at a number of these, and a number of self-assessments, which all reported full compliance with the CMMC, with the NIST 800-171 requirements. And when they looked at them, 75% had major deficiencies, and 100% had at least some deficiencies. That's, kind of striking that you had all of these companies that thought they were in full compliance were not, which brings us to, kind of the future, which we've all heard so much about, CMMC. CMMC is the cybersecurity model created by combining various cybersecurity standards. It was first announced several years ago prior to COVID-19 and has been continuously delayed. And the purpose of this model is to provide a third-party assessment of different contractors' cybersecurity practices. I guess it's adding to, or in the old Reagan concept of trust but verify, or in the new parlance of cybersecurity, zero trust. When they first rolled out CMMC, which is called CMMC 1.0, it included 5 levels of certification. Third-party certification was required for all 5 levels. Level 3 was the full NIST 800-171 requirements. And the plan was to require all DoD contractors to have a CMMC rating as a gating item before they could bid on Defense Department contracts. There was a understandable, outrage or concern from most contractors, but particularly small businesses, complained about the cost, the time, and the uncertainty of certification. It really presents another barrier to entry to the federal market. You also have these long supply chains where you're the second or third tier subcontractor. How much you're able to invest in these cybersecurity controls when you're not even guaranteed to get a contract or to get a subcontract that requires them. So that led DoD to scrap CMMC 1.0, and last year they announced CMMC 2.0. Newer, bigger, better. Well, I shouldn't say bigger because it's smaller. CMMC 2.0 got rid of levels 2 and 4. Only has 3 levels. Level 1 is still the most basic, and is essentially the requirements for FCI in 52, 204, 21 that we talked about earlier. And level 1 does not require a third-party assessment. At that level, contractors are presumably going to be permitted to self-certify. I say presumably because we do not have the full rollout of the proposed rule yet. For level 2 and level 3, which is companies that have access to CUI, they're going to need third-party certifications, and they've started to certify third-party certifying organizations that are offering these services. The full timeline for when CMMC is going to be rolled out is unclear. If you read anything at the beginning of the year, the expectation was that the new CMMC rule was going to be out sometime in spring 2023. Well, as we are all spending our time attending end of the school year events, we understand that DoD missed that deadline. And we are now expecting the rule sometime this summer or early fall. And it's going to be issued, the current plan is that the DoD is going to issue it as a proposed rule, which means it will not be effective at the time it is issued, and it will not be effective until there'll be a comment period of 60 days, although likely longer, so it will likely get extended, but don't count on that. And then for a rule of this size, it will, best estimates right now, it will take a full year before they're able to go through all the comments and issue a final rule. So full implementation is not really expected until summer or fall of 2024.
Great. So as Kevin was explaining a few slides ago, some of the DoD's clauses that it uses to enforce the requirements in this special publication 800-171. Of those, one of those he mentioned was the -7020 clause, which permits the government to assess a contractor's compliance with those 110 controls by gaining access to the systems and the facilities of the contractor. Well, after the government assesses the contractor's compliance, the score will be for the assessment will be posted into the Supplier Performance Risk System, or SPRS. So SPRS is a DoD application that generally provides supply chain risk scores with regards to a contractor's supply chain. How risky is it? And notably, the SPRS takes data from various sources, not only just these assessments, but also FPDS, the DCMA, and CPARS. Well, here on this slide, Kevin and I recently blogged about a new rule that now requires contracting officers to consider the information in SPRS when evaluating proposals and a contractor's responsibility. And it'll be at that DFARS clause 204-7024 that's on the slide. So currently it's unknown how much or how little contracting officers will utilize the information in SPRS. It's not required to be a standalone, and it won't be a standalone source selection evaluation factor. And currently, it's only applicable to DoD contracts. Contractors, we recommend they should ensure the information in SPRS is up to date. So when it comes time for proposal evaluations, you won't be unnecessarily downgraded or even removed from the competition due to a high-risk supply chain score from SPRS. So thus far, we've been primarily discussing DoD cyber requirements. Along the same lines, the Department of Veterans Affairs, the VA, recently rolled out some new contract clauses that will also increase contractors' compliance obligations as well as reporting requirements as it relates to the information that they're handling on their systems. So here, a new rule was issued and implemented by the VA, adding new language to their FAR supplement, the VA-AR, and implementing new contract clauses to be included in certain VA contracts. So the VA is primarily interested in VA-sensitive information, which the clause defines as including all VA data that requires protection due to the risk of harm that could result from inadvertent or deliberate disclosure, alteration, or destruction of the information. So if a contractor has access to this information, they'll ultimately be required to comply with a host of VA information security and privacy program guidance, as well as complete annual VA security awareness training. So I know Kevin was discussing a 72-hour reporting requirement. Well, here, even more shockingly, and most notably from this rule, contractors that know of an actual or suspected security and privacy incident regarding VA-sensitive information will be required to report it to the relevant authorities as identified in the contract clause within 1 hour of its occurrence. And in addition, the new contract clauses for the VA will require if a contractor employee working on a VA information system is reassigned, leaves, or is unfriendly terminated, the contractor will be required to report this within 4 hours to the relevant authorities identified and program managers in the contract clause. And I think one thing I did want to note was that there are some nuances to the rules and the new FAR clauses as it relates to VA IT services contracts. There, contractors will have to submit information system security plans within 90 days after contract award. So I just want to highlight some of the new compliance measures and reporting obligations coming out of the VA, which is just one of the many agencies rolling out these new cyber requirements.
Yeah, it's really important that when you get your contract, you look at those cyber requirements. If they're in an agency-specific clause, or if there are some, it's not a standard clause and they're just separate requirements. Because, the 1 hour reporting or the 4 hour reporting, if an employee is reassigned, that can be really easy to miss if you don't have a process in place well ahead of time for providing that kind of notice. These are definitely, in all cases with, breach incident reporting and in breaches in general, breach response, you need a plan in place ahead of time, because things are going to get crazy on the ground when a breach happens. You may lose access to parts of your system. You may be trying to find backups. You may be scrambling to find lawyers or vendors, forensic people who can help you with these things. And it's really important that you have those ahead of time or have an idea of where you're going to go ahead of time, especially when you have 1, 4, or even 72-hour reporting obligations.
Great. Thanks, Kevin.
I'll get off my soapbox now.
So here we're going to switch gears slightly and talk briefly about some supply chain risk and some new rules that contractors are going to have to comply with regarding their supply chains. So before we get into some of the newer rules, here is a contract clause from the DoD FAR supplement, 239-7018, entitled Supply Chain Risk. The DoD actually defines supply chain risk in this clause, or we provide the definition right there. I'm not going to hash through it. But similar to some of the other definitions we've been discussing, this one as well is fairly broad. And notably, this clause goes on to require that contractors mitigate any supply chain risk they may have, but it also allows the government to consider information, both public information and non-public information relating to a contractor's supply chain, and, if they deem it necessary, exclude them from the competition to reduce any supply chain risk in the procurement. And this clause also expressly waives one's ability to bring a bid protest challenging the DoD's actions here. So in order to challenge them at all, contractors, if removed from the competition, would likely have to challenge the agency action in federal district court as being arbitrary and capricious. They would not be allowed to bring a bid protest against the agency.
And that's even if you find out that the agency did this, because there's no, it can be based on non-public information, and there's no real requirement that you receive notice or an opportunity to respond. We had one matter where a client had a mandatory source of supply contract, and out of the blue, the government issued a memo that said that their product was a supply chain risk. And when we tried to dig down, we found out that some, is tagged as part of an automated system, and that even though their products were manufactured in a plant in the United States with parts that were almost exclusively American made, the computer had tagged them as a supply chain risk because critical components were assembled in China. That's all we would be told. And it took quite a bit of phone calls with high-level agency officials to unpack all of that and get the contract restored and try and get them some kind of compensation for all the orders that were canceled and not placed. So the amount of power that the government is getting and the Defense Department has to mitigate these supply chain risks is actually pretty amazing. And hopefully it is more of a case that with great power comes great responsibility, as opposed to absolute power corrupting absolutely. So we'll see as this clause, which has been around for a little while, continues to be used, and which of those 50 maxims prove to be correct.
Awesome. Thanks, Kevin. So moving on, all agencies regarding supply chain risks in their software are required to ensure they're procuring software in a way that enhances the security of the software supply chain by complying with a secure software development framework. So in order to ensure contractors have this secure software supply chain, agencies will soon be collecting the self-attestations from companies providing software to the government. This has kind of been going on in the background. There's a draft common form for the self-attestations that's been released by CISA. There's a component of the Department of Homeland Security where the public comment period actually ends in a few weeks on June 26th. So if you want to take a look and submit a comment for the self-attestation. So these attestations are going to be required currently from software producers who produce or develop software that will be used on an agency's information system or otherwise affect the agency's information. I think software in the draft form is broadly defined to encompass firmware, operating systems, application services, as well as any products containing software. And I think with these self-attestations, I think the main question we're even getting is how will this apply to resellers of software, which is a major industry in government contracting. Unfortunately, the memos and the draft attestation form do not provide much clarity on this. But we're hoping when the draft form is finalized, this detail will be hammered out and we'll be able to tell whether resellers of software will have to provide the government these self-attestations, or simply just the software producers who may be lower down in the supply chain. And I think it's important to note that these attestations are the baseline as a requirement from an OMB memo, I think back in 2022. So there will likely be agency-specific memos implementing this requirement and adding even more requirements on top of these self-attestations. Remember, this is just the baseline. And a GSA has already issued a memo, which I blogged about a few weeks ago, kind of giving some guidance on how these attestations may, or what software is being provided to GSA are going to affect existing contracts. I think timing-wise, it's important to note that the relevant OMB memo that I've been mentioning requires agencies to collect attestations regarding critical software, which has a specific definition in the memo, beginning next Monday, June 12th. The agencies are going to be required to collect this, and for critical software only, and may also request a software bill of materials along with those attestations.
So Daniel, just trying to understand how this is all being rolled out, but this is a OMB requirement to agencies, correct?
Correct. That's correct. And the agencies in turn are the ones requiring that the software they are procuring has a limited or very low or no supply chain risk to their procurement. And that's where the attestations come in. They want to ensure that the software they're providing or they're procuring meets certain baseline requirements in the secure software development framework as described in that NIST special publication on the slide 800-218.
Yeah, this has been rolled out very quickly and is one of the many fast developing areas of cybersecurity.
Definitely. So here is the line on the TikTok ban. So for those that don't know, TikTok is a video hosting service owned by a Chinese company by the name of ByteDance Limited. And it has especially become popular predominantly amongst the younger generations. And
this is why I gave this slide to Daniel. Sorry to interrupt, because he speaks. Well, I'm just a aging millennial / Gen Y. Daniel, he speaks Generation Z.
Exactly. So I'm happy to cover this new ban on TikTok. I know a lot of people currently use, especially around my age. So an interim final rule effective last week added a new clause to the FAR that will be included in almost every solicitation and contract moving forward. It'll also, agencies will also be modifying it into several types of existing contracts too. So in short, the new FAR clause prohibits having or using TikTok on any information technology, IT, used or provided by the contractor under a contract, including equipment provided by the contractor's employees. So I think that's the major takeaway from this interim final rule, but I think there's a couple nuances that make it that could potentially make it much broader than what it appears on the face. First, the prohibition applies to any successor applications or services provided by the company ByteDance, as well as applications or services developed by entities owned by ByteDance. So I think the vetting of the applications that are on your devices that are being used in the performance of the contract will be much more significant than just looking for TikTok, but these other apps too that ByteDance owns or rolls out, or an entity owned by ByteDance rolls out. So this requirement must also be flowed down to subcontractors. And I think the other very important nuance to this rule is that the prohibition and ban on TikTok will not apply to contractors' employees' personal devices that are not used in the performance of the contract. So, yeah, and this was just made effective last week.
Yeah, which is interesting. And I think where this, I don't think there are many government contractors who are actively using TikTok in performance of their contract. I'm sure there are a few, but any employee who has a bring your own device and their teenage daughter or teenage son, had them download TikTok to watch their videos of doing whatever. I'm shaking my fist at clouds right now, by the way, if you can't see me. But those those bring your own devices are, potentially a significant compliance issue if they have TikTok on them and they use those devices for work. So this is kind of a sneaky clause that could have a lot of breadth. So in addition to some of this software where we see the government cracking down, there's also has been for quite a while, a crackdown or a limitation on, some of the hardware. I think at this point we've all heard the phrase, Section 889, which prohibits the use of the sale or use of certain telecommunications equipment. And that refers to the National Defense Authorization Act of 2019. And it basically says that you cannot sell to the government or, more significantly, use certain Chinese telecommunication or video surveillance equipment in your performance of the contract. It's very similar to this TikTok ban. The word use is relatively undefined and potentially extremely broad. It covers products made by Huawei, ZTE, any of their affiliates. There is you can track down a list of the latest and greatest list of affiliates on SAM, on the exclusions list. It also allows for the Secretary of Defense in consultation with some other government officials to add companies to the list. But again, they'd be added to the list that's available, that is published. Section 889 is implemented through FAR 52204-25 and 52204-26. And in order to make these certifications that you are complying with Section 889, federal contractors are required to make a reasonable inquiry to determine if they are using or providing banned products. This is kind of a gray area. What extent is a reasonable inquiry? But this is your telephone that you're using, your internet router, your cell phones. These are all products that are very common in the supply chain, and we're not allowed to use them if we're on any equipment that's being used for a government contract. So this can be somewhat of a heavy lift, and a reasonable inquiry can become unreasonable very, very quickly. So now we've thrown a lot of information at you about different cybersecurity controls, different types of information that you need to protect in different ways, software that's prohibited, hardware that's prohibited. And now it's kind of the so what? What's the big deal if we can't listen to, if we can't follow all these rules? For starters, there are contractual remedies. DoD issued a memo last summer gently reminding contracting officers that failure to have or make progress on a plan to implement NIST 800-171 may be considered a material breach of contract. That's a scary phrase. A material breach of contract means they can withhold progress payments. It means they have a reason not to exercise options, or maybe they're even prohibited from exercising options. It can also be grounds for termination in whole or in part. And that's even for the scenario where you said you were working towards meeting, maybe 3 of the 110 NIST 800-171 requirements, and you haven't, made any progress on those. Never mind situations where you may have represented that you meet all of the NIST 800-171 requirements, and it turns out that you didn't. That type of situation puts us more in line with, the False Claims Act liability. The False Claims Act is as old as the Civil War. I don't think President Lincoln, when he signed it into law, was thinking that it was going to be used or could be used for cybersecurity, but it is absolutely one of the arrows in the government's quiver. And there are a lot of ways where False Claims Act liability can attach. The self-attestations from software producers and the software bill of materials, If those are misleading or inaccurate, that could be grounds for a False Claims Act argument. Self-evaluations of the NIST 800-171 compliance, that's fertile ground for compliance issues. Use of banned telecommunications products under Section 889, or the failure to conduct a reasonable inquiry. What's particularly scary about the False Claims Act is there are two ways you can get in trouble with it. There is the federal government bringing False Claims Act charges against you, where they're making the allegations that you are somehow violating or have submitted a false claim after you are not in compliance with one of your contractual obligations. And in fact, the government has indicated that cybersecurity is one of its, big targets, and they created the DOJ Civil Cyber Fraud Initiative, which is actually looking to hold companies and individuals accountable for putting sensitive information at risk. In the first such settlement, it was all over the news. I believe it settled last summer. It was a $9 million settlement stemming from allegations that the company misrepresented its compliance. And equally as scary is whistleblowers. So these are company employees who may have been involved in coming up with your NIST 800-171 compliance. And maybe they're the person in the room saying, guys, I don't think we meet this control. How are we saying that we have, this level of encryption when under these circumstances it's not quite up there? Or they're asking, oh, well, shouldn't we look at some of our affiliates to see if they're using prohibited telecommunications products? Why are we stopping our reasonable inquiry where we are? And the argument there is, for these False Claims Act liability, you do have to. It has to be a knowingly making a misrepresentation, but that standard can be a little bit lower than it sounds, because it also applies if the ostrich in the stand idea, you cannot, fail to follow up on, reasonable leads, or intentionally be ignorant about your cybersecurity and compliance. And the other, thing that makes False Claims Act liability so scary is you could have a whistleblower come out of the woodwork and make allegations, and then you spend 2-3 years on the wrong end of a government investigation, and even at the end of it, they determine that no, this was just a casual, no fraud and fraudulent intent. You've now spent, hundreds of thousands of dollars in legal fees and in other just work disruption, all because of what DOJ saw as a credible threat. So that's kind of one of the scary things of why we're so worried about cyber regulations and why we're trying to stay on top of what we're supposed to be doing to protect this information. Daniel, what's coming up in the world of cyber regulations and what's on the horizon?
Yeah, thanks, Kevin. Yeah, so we got a few things besides CMMC that are developing and are on the horizon that we think you guys should be keeping an eye out for. So first, a new CUI rule that plans to implement the CUI requirements, which are currently just in Title 32 of the federal regulations right now. This rule will implement these requirements and standardize them into FAR. However, currently we're still waiting the proposed rule, and there's not a hard, fast timeline on that, or really even what stage that we are at in that timeline, as there hasn't been an update in a little while now regarding this CUI rule. Next, there is a new language planning to be added into the FAR to standardize some of the cybersecurity requirements for unclassified federal information systems. So a draft proposed rule is actually currently under review by the Office of Information Regulatory Affairs. That update came last month, so we should most likely see this proposed rule, or we anticipate seeing this proposed rule prior to standard CUI requirements mentioned in the first bullet. Lastly, some may have heard last year, the Cyber Incident Reporting for Critical Infrastructure Act of 2022 was passed. And there are several reporting obligations regarding covered cyber incidents included in that act, as well as a 72-hour notification requirement. And the proposed rules actually implementing and making those notification requirements effective, we believe should come sometime next year. So should definitely be on the lookout for some of these new developments outside of the world of CMMC that might come through this year or the following year. So here are some of the impacts of the cyber requirements that were discussed throughout the webinar and how those impacts affect small businesses. So indeed, the evolving cybersecurity requirements present an opportunity for small businesses to gain a competitive advantage by investing in the compliance. You'll definitely be more sought after, especially by certain teaming partners when it comes to going after, especially DoD contracts. However, on the flip side, these requirements also present a potential barrier to entry into the federal marketplace for small businesses. At the prime contract level, we're often seeing more frequently self-scoring procurements, and these cyber requirements make it increasingly difficult for small businesses alone to stay competitive without making the necessary investments in cybersecurity like their larger competitors or other small businesses. And these types of self-scoring procurements, it may almost be necessary to team with a large business, but we all know that isn't always feasible. And from the subcontract perspective, prime contractors are increasingly requiring prospective vendors to comply with more stringent cybersecurity requirements and supply chain risk mitigation measures. So this could be another potential barrier. And if you're the subcontractor, you want to push back and make sure that primes are not flowing down unnecessary, overly burdensome requirements that don't apply to you, depending on the type of information, FCI or CUI, that you may be working on as a subcontractor. So I think in the end, to hurdle some of these obstacles, mentor-protege relationships may be the right path, since they'll allow small businesses to obtain the necessary assistance in enhancing their cybersecurity from their large business mentors. And I think ultimately, these joint ventures are going to be a very popular tool moving forward for small businesses to maintain compliance with all these requirements.
Yeah, I think one way or another, small businesses, they were pretty successful in getting the first iteration of CMMC revised. At the same time, I think small businesses should think of these increasingly burdensome cybersecurity regulations as an opportunity, because DoD in the past couple of years and on the Hill, you hear talk about expanding the size of the defense industrial base, and you also hear about zero trust and the importance of cybersecurity. So if you have small businesses who can participate in the defense industrial base that have these cybersecurity controls in place, they're going to be an attractive sole source. They're going to be an attractive subcontractor. They're just going to be attractive for a number of reasons. So I see we are slightly over time. We had a lot of questions that we were not able to get to. So we will try and follow up individually. And I just wanted to, we covered a lot of things and we covered them at a very high level. Almost every slide we presented today probably could have been a full, half hour, if not full hour discussion. So we do recognize that we did not capture all of the nuance of every topic. That was partially by design, and that we wanted to present as much information as possible to really get everyone thinking about what their cybersecurity level of compliance is right now, and understanding where it's going to go in the future. And I think we should all be working towards meeting some or all of the NIST 800-171 compliance requirements. Certainly all of the basic safeguarding controls. And if you do have any questions about your company's ability to meet those, or questions about what your compliance obligations are, a lot of questions about CUI versus FCI, CUI versus CDI, we're happy to talk about those, and we can get into a very nuanced and in the weeds discussion that wouldn't necessarily be appropriate for a big webinar. So thank you very much, everyone, for attending, and we hope that you had as much fun as we did presenting.